Welcome to Module 2.3, Lease Negotiation and Setup. My name is Quaker Tabby. I'm a real estate lawyer and partner at Castles Brock & Blackwell LLP, a law firm here in Toronto. Before we begin, I would like to note that this module is provided for general information purposes only. Castles is not providing legal or other advice, and you should obtain independent legal and other advice as needed. Let's begin. It is not uncommon for landlords and tenants to negotiate unique leasing terms. Every business has different needs, so this step is important to craft a lease that is right for you. These terms are usually summarized in what is referred to as an offer to lease. Contrary to its name, if an offer to lease is signed by both parties and contains no language to the contrary, it will be binding on all parties. With this in mind, be sure to pay careful attention to anything agreed to in an offer to lease, and do not sign any such agreement if they contain terms you don't want to be bound by in a lease. There are a number of provisions that are typically negotiated as part of an offer to lease and in the lease itself. First is the form of lease, whether it be a net lease or a gross lease. As discussed in Module 2.2, a net lease has the tenant pay the basic rent plus additional rent, which can vary from time to time, while with a gross lease, the tenant pays one set amount as rent, which covers their basic rent and all other expenses without any variation. Next is rent. Basic rent, additional rent, and in retail context, percentage rent are typically established at this stage. Each of basic rent and additional rent are usually determined on a price per square foot basis. Next is use, one of the most important concepts. It is important to establish in the beginning what your intended use of the property will be, and whether the landlord is subject to any exclusives or restrictive covenants that would impact your use of the leased premises. As an example, if you're looking to open a shoe store, it is important to know whether the landlord leases to any other shoe stores that would be a direct competitor, and whether that shoe store has an exclusive right to sell shoes at that location. Next is parking. If your leased property contains parking spaces, you will want to be sure that you have a right to use an adequate number of those spaces for your clients. If needed, you should look to secure a number of exclusive parking spaces for your leased premises. Perhaps the space is located directly in front of your storefront. You should expect that you as a tenant would be responsible for enforcing the exclusivity against others, and for the landlord to not be involved. Another important concept is options to extend. Options to extend a lease is a provision which provides the tenant with the right to carrying on their lease for a prescribed period of time. Ensuring you have this option will allow you to keep the goodwill you have built up at your brick and mortar location. Further, these options can specify how much rent will be charged, although it is a common practice for the option to state that the rent will be negotiated closer to the exercise of the option at the then prevailing rental rates. Leases will often stipulate a security deposit, which is typically the first and last month's rent. When the deposit is paid, how much it is, or if one is required at all, are all things up for negotiation. Next is landlord work or tenant work. Tenants can sometimes get the landlord to agree to provide upgrades to the property at the landlord's expense. Some examples may include a new heating and ventilation system, a new roof, or even a new electrical system. Negotiating landlord works can be useful for properties that are well situated but may be older or in a state of disrepair. This would also be an opportunity to set out the tenant's anticipated improvements to be made to the space and to obtain the landlord's approval for that work. Finally, restrictive covenants. These covenants can limit which types of business a landlord can rent to. As part of your lease, you can negotiate which restrictive covenants to limit the amount of competition in your immediate area. It is also important to understand what restrictive covenants the landlord is already subject to and how that may impact your use. If the location is shared with other tenants, it is best practice to reach an agreement as to what the additional rent will be, typically estimated on a per square foot basis, and what the tenant's estimated additional rent calculation will be for the upcoming initial year of the term. Again, these are just a few of the many terms that can be negotiated. Unlike in residential leasing, there is no standard lease form. Understand your bargaining power and don't be shy to push back on any terms that are unreasonable or unfavorable to you. Promotional fund or advertising clauses are lease provisions which require tenants to contribute to a pool of money that is managed by the landlord. Promotional funds are used for advertising and promotional activities that attract customers to the property for the benefit of all tenants. This can be common in properties with multiple tenants such as shopping centers. When assessing these clauses, pay special attention to three key factors. First, the contribution. Tenants typically pay a set amount per square foot of their leased space, often as additional rent. You should also be cognizant of the use. These funds can be used for a number of different activities. These can range from marketing campaigns to holiday decorations. And finally, administration. The landlord usually manages the fund, sometimes with input from tenant representatives. A fixturing period in commercial leasing is a designated time frame before the official start of the lease, during which the tenant is allowed to access the property to prepare it for business operations. This period is typically used for tasks such as construction, installing fixtures, setting up furniture, and stocking merchandise prior to the grand opening of the store. In longer leases, this is sometimes accompanied by a rent-free period, where tenants do not pay rent, although they may still be responsible for utilities and insurance. The goal of a fixturing period is to allow tenants to get the space ready without any immediate financial burden, with the ultimate objective of enabling them to begin operations smoothly when the lease term officially begins. Transfer clauses in a commercial lease outline the conditions under which a tenant can transfer their lease rights to another party. These clauses are important as they define the flexibility and limitations of transferring the lease. The main types of transfers are assignment, where a tenant transfers their entire interest in the lease to another party. The new tenant, or assignee, takes over all responsibilities and benefits of the lease. A sublease. This is where the tenant, referred to as the sublessor, rents out part or all of the lease premises to another party, known as the sublessee, while retaining some rights and responsibilities under the original lease. A transfer of control occurs when the tenant transfers their ownership interest in the business, which may include the lease as part of the business assets. A transfer of control can also occur if there is a transfer of the majority of the shares in the business to a third party. Property sharing involves the tenant allowing a third party to use the property alongside them. This is less common and usually requires specific consent from the landlord. Not all transfer clauses are created equally. A number of conditions should be considered when assessing if a transfer clause is beneficial or harmful to your business. First, landlord's consent. Most leases require the landlord's consent for any transfer. Where possible, your lease should specify that such consent cannot be unreasonably withheld, delayed, or conditioned. This would mean that the landlord cannot arbitrarily decide to withhold their consent and must present a valid business reason for denying their consent. Permitted transfers. Some leases allow transfers without landlord consent under specific conditions, such as transfers to an affiliate of the tenant or as part of a reorganization of the corporate tenant. The process and timing. The lease should outline the process for requesting consent and the time frame within which the landlord must respond. Finally, reasonableness. The lease may define what constitutes reasonable grounds for the landlord to withhold consent, such as the financial stability of the new tenant. Dispute resolution clauses in commercial leasing agreements are provisions that outline the method and process for resolving conflicts between landlords and tenants. These clauses are important for managing disputes efficiently and minimizing disruptions to business operations. Some common types of dispute resolution clauses include negotiation, where this clause would require the parties to attempt to resolve disputes through direct negotiation before pursuing other methods. Next is mediation. This involves a neutral third party who helps the disputing parties reach a mutually acceptable solution. Mediation is typically non-binding, meaning the mediator does not impose a decision. Another method is arbitration. In arbitration, a neutral arbitrator hears both sides of the dispute and makes a binding decision. This process is less formal than court proceedings and can be faster and more cost-effective. Finally, there's litigation. Some leases may specify that disputes will be resolved through the court system. This is usually a last resort due to the time and expense involved. There are also cooling off periods. These clauses allow a set period during which parties must wait before escalating the dispute, providing time to resolve issues amicably. In Ontario, arbitration clauses are governed by the Arbitration Act. Unless the lease provision provides to the contrary, you will need to look to this act to see, first, how your arbitrator will be appointed, how awards will be granted, what rights you have to challenge any decision, and much more. It is important to carefully read and understand any arbitration clause in your lease. The courts have regularly refused to hear issues that arise out of a lease that is governed by an arbitration clause. In these cases, they have required the parties to proceed with arbitration first, and in rare instances have refused to intervene at all. As such, understanding what dispute resolution method is right for you is of the utmost importance. A tenant improvement allowance is an amount of money paid to a tenant by their landlord for the purpose of customizing or improving the leased premises. This allowance helps tenants modify the space to better suit the needs of their business, such as installing new lighting or partitions. Some key things to consider in any tenant improvement allowance clause are the amount of the allowance, which is usually negotiated and included in the lease agreement. The allowance may be expressed in a dollar per square foot basis or simply as a whole number. Next is use of funds. Typically, allowances are specified for a particular use, the most common being construction-related costs such as architectural modifications or interior finishes. Close attention should be paid to any express limitation placed on the usage of the funds. Next, payment of funds. The allowance clause will also usually say both who the payments are made to and when. It is not uncommon for larger allowances to be paid incrementally at designated construction milestones. At these milestones, there are likely to be certain deliverables by the tenant as well, such as statutory declarations demonstrating that the construction has been completed in accordance with the Construction Act. While not common to every commercial lease, these allowances help to reduce the cost of setting up a brick-and-mortar business. In the context of commercial leasing, landlord covenants are promises or obligations that the landlord agrees to uphold during the lease term. These covenants outline various responsibilities and rights of the landlord. Some common landlord covenants include the covenant of quiet enjoyment, which ensures that the tenant can use the lease premises without interference from the landlord or other parties. It guarantees that the tenant's possession and use of the property will not be disturbed. Maintenance and repairs. The landlord may be responsible for maintaining the structural integrity of the building and common areas, as well as making necessary repairs to ensure the property is safe and habitable. The landlord must also ensure that the property complies with all applicable laws, regulations, and building codes. Also, the landlord typically agrees to carry insurance for the building, covering risks such as fire, natural disasters, and liability. It is important to note that the landlord retains the right to enter the premises for necessary repairs, inspections, or to show the property to prospective tenants or buyers, usually with prior notice. These covenants help define the landlord's duties and protect the tenant's rights, ensuring a clear and fair leasing relationship. In Ontario, the rules around landlord access in commercial leases are primarily governed by the terms of the lease agreement. Some general concepts that can be found in a lease are reasonable notice, such that some leases provide specific timelines around landlord access. In many instances, they are required to provide reasonable notice to the tenant, typically at least 24 hours, before accessing the premises, unless there is an emergency. The definition of reasonable notice can vary, but should be specified in the lease agreement. Many leases permit landlords to access the property for specified purposes, such as performing necessary repairs or maintenance, inspecting the premises to ensure compliance with the lease terms, and showing the property to potential tenants near the end of your lease term if you have not renewed, or potential buyers or lenders. Emergency access. In cases of emergencies such as fire or significant damage, landlords may enter the premises without prior notice to be able to address the issue. Again, tenants have the right to quiet enjoyment of the premises, meaning they should not be unreasonably disturbed by the landlord's access. It's important to review your specific lease agreement to understand the exact terms and conditions regarding landlord access. Commercial leases often will include insurance coverage requirements that the tenant will need to abide by. These provisions will specify which kind of insurance is needed to be held and in which amounts. Some examples of the types of insurance that may be required are all risks insurance, which is general insurance for all risks, including flooding and earthquake, to a property. Machine and repair insurance, broad form boiler and machinery insurance on a blanket repair and replacement basis. Business interruption insurance. This insurance provides coverage for the direct or indirect loss of earnings attributable to all perils. Public liability and property damage insurance. This insurance provides coverage for personal injury liability, bodily injury liability, tenant legal liability, contractual liability, and owner's protective insurance coverage with respect to the lease premises. It is important to work with an insurance broker to ensure that you are able to obtain the necessary insurance that meets the landlord's requirements. You should expect that the landlord would require that they be included as an additional insured under the policy so that they are protected as well. Every business needs a sign to attract clients. Commercial leases will contain a number of provisions relating to signage that may be posted by a tenant. It is important to understand what limitations, if any, your landlord may put on signage, such as the size, location, and when signs must be lit. Particularly in locations with multiple tenants, the landlord may stipulate during what hours the signage must be lit, so that there is cohesion amongst all the tenants. Equally important is understanding what your responsibilities are when it comes to taking down these signs. At the end of the tenancy, most tenants are required to return the lease premises to a condition similar to the condition they received it in, with few exceptions. These exceptions may or may not include signage put up by tenants during their tenancy, and repairing any damage that may be caused by the removal. Lease premises may be subject to a restrictive covenant which can limit the available uses and can be imposed by other tenants if property is multi-tenanted or by third parties. Restrictive covenants are essentially an agreement between the landlord and another party to not allow their property to be used in a certain way. For an example, an existing fast food burger restaurant may have an agreement with the landlord that prevents the landlord from leasing to another burger restaurant. These covenants may affect the products and services you are able to offer. Be sure to review these provisions carefully to ensure your current and future product offerings are not unduly limited. Earlier, we discussed the limitations on the building's use that stem from landlord covenants. However, every lease agreement is also subject to local building and zoning laws. When planning your ideal store layout, be sure to consult local zoning laws. Some features, such as a walk-up delivery window, may be permitted on the terms of the lease, but prohibited by local zoning laws. It is also important to consult the laws, rules, and regulations specific to the business you are looking to start. As an example, a cannabis store is required to be a certain distance from schools, have certain window coverings, and certain requirements governing signage. Registering a lease acts as notice to anyone who may otherwise have a right to evict you from your property. For example, if a landlord enters into bankruptcy, their bank may take possession of the property, attempt to evict you, and then sell the property to make back the money on their loan. Registering a lease can help protect against this by notifying the general public of your interest in the property. In Ontario, registration is effected by registering a notice of lease, which sets out certain pertinent information about the lease, including the term and if there are any extension rights. The parties have the option of attaching the entire lease or a short form of lease to the registration. If the lease is not attached to the registration, then a copy will need to be provided to any party requesting a copy within 14 days of the request, or the registration can be removed from title to the property. Each method offers different rights and remedies, which can be important and strategic depending on the situation. Registering a lease does not impact its validity between the landlord and tenant. However, it can affect the lease's priority compared to claims by a future landlord or mortgagee. As a tenant, you cannot predict when a landlord might sell or mortgage the property, and may not be able to inform all future buyers or mortgagees about the tenancy. By registering your lease, you can ensure you give the required public notice and secure your priority. The Planning Act is a provincial law designed to control the subdivision of existing plots of land. While it has obvious implication for those buying property, it also applies to leases as well. Some important things to consider include lease duration. The Planning Act generally prohibits leases from having a term longer than 21 years, including renewals, unless specific exemptions apply. You should consider whether those exemptions apply. There are several exemptions to this rule. Generally speaking, if the lease premises form part of a building with other tenants, then it is exempt from the Planning Act. For more certainty on Planning Act exemptions, we recommend you consult a legal professional to make a more concrete determination for your location. If a lease does not fall within one of the stated exemptions and exceeds 21 years, it may require consent from the appropriate authorities. Without this consent, your lease could be considered void. Again, it is best practice to speak with a legal professional who can examine the title to the property and the lease to ensure that the lease would be compliant with the Planning Act, or to identify when a consent may be required. Thank you for joining me for this discussion on lease negotiation and setup. For any specific questions or concerns, please do engage a legal or financial advisor to assist you in starting your new business. Good luck.